But I thought I would just start by giving you a little bit of context, because as you probably noticed, this paper that you've been asked to read or given the opportunity to read looks quite different to the other papers that you've read, in previous workshops. So it's obviously not written in the more traditional academic article style. And that's because Adil and I, when we first started talking about what we might like to do on this topic, we felt that, and in fact, also talking to others that in a similar sort of workshop last year, there was sort of a sense that there was a need for really sort of focused legal analysis on the compliance of the CAA with India's international law obligations, particularly in a way that might feed into the Supreme Court litigation. Now, just to clarify, we're not intervening in the Supreme Court litigation, so this is obviously not an amicus brief. We haven't written it for the purposes of feeding into an amicus brief, but we just felt there might be some utility in writing something that perhaps could be picked up by someone who's litigating before the court. Now, obviously, some of you, well, all of you probably understand the Indian court system much better than I do. And from what I understand, there's a lot of different briefs that have gone up. So lots of different cases. I'm not sure whether they'll be consolidated into one hearing or how that will work. I guess in terms of what's out there so far, the main brief that's similar to ours is the, of course, really good brief that's been put in by the Office of the High Commissioner for Human Rights, as you probably know, that they're intervening in the case. And of course, they put in something that does touch on some of the arguments that we've raised. But we still felt, having read that there was perhaps a little bit more work that could be done. And so this is really, why we put this together. Adil will raise for you some of the questions that we have, in particular around strategy and, who's actually writing this, whether we should sort of be seeking endorsements and making this a kind of a wider publication, if you like, and then also what we might actually do with it. But I thought I would just run you through some of the core arguments, albeit very briefly. I guess in terms of, so that's to give you a bit of an idea of why we've done this. And then I suppose in terms of the strategy, we have really tried to focus in, it's quite a conservative brief in a sense. And what I mean by that is that we've heard some really interesting arguments so far in previous workshops in these roundtables about, arguments that you could make about the deprivation of nationality amounting to a violation of the right to life and right to dignity under the Indian Constitution. I think there's some really quite creative arguments that could be made in this context. I suppose because we're not writing this as an academic article, but rather trying to feed into a process that we feel is perhaps more amenable and receptive to, fairly sort of focused arguments. We haven't necessarily explored, the full breadth of what one might argue. So to give you one example, I've been doing quite a bit of work on separately in another project on racial discrimination and citizenship, and in particular looking quite closely at the International Covenant on the Elimination of Racial Discrimination, which of course India is a party to, but we decided not to raise that, at least for now, and that could be a question for discussion. But we just felt that trying to argue this as sort of race or ethnicity discrimination might be more complex, and again might just sort of seem overly or perhaps a little bit political. So hence we focused mainly on the ICCPR. So just to give you again a really quick overview, in terms of, I don't want to turn this into a lecture on international law because I'm sure all of you are aware of the key provisions. But when we talk about international law and nationality, everyone naturally and quite appropriately begins with Article 15 of the UDHR, which proclaims that everyone has the right to a nationality. I suppose what we want to observe immediately is that the UDHR is not binding. And it's also an incomplete right in that it doesn't actually impose an obligation on any particular state to grant that nationality. So you can go around saying, I've got a right to a nationality, but who's the state that you're going to put that right to and sort of claim in return the obligation? And so what that means is we need to find some kind of binding obligation in an international treaty. And as we've outlined at page 4, I think, of the brief, we've outlined the different treaties that India has ratified, but the one we have focused on is the ICCPR, in particular because of Article 26, which is a freestanding right to equality or non-discrimination provision, which we know based on a lot of authority that from the Human Rights Committee, that Article 26 applies sort of independently. So you don't necessarily have to find a right to nationality in the ICCPR for Article 26 to kick in. And so Article 26 is set out there that all persons are equal before the law and entitled without any discrimination to the equal protection. And the grounds, of course, in Article 26 that are relevant to us are religion and potentially national or social origin. So as all of you will know, the argument that everyone is really pointing to is that the CAA on its face discriminates, or at least differentiates, is perhaps the more neutral way to phrase it initially, on the basis of religion and country of origin. And so, of course, the question that we examine is, well, does that differentiation amount to discrimination? Because we all know that not every differentiation does amount to unlawful discrimination, even where it is on a prohibited ground. And so what we really do in this brief is to examine that in some depth, in essentially putting the government's arguments and sort of case to the test by saying, all right, let's not assume that it's necessarily discrimination. Let's say there's a differentiation that could in fact be justified. So let's sort of pull apart, particularly as is outlined in the statement of aims and objects, if I've got the title correct, where the government actually outlines the rationale for the Act. Let's pull apart each of the rationales in that statement and see if it withstands scrutiny. So I'll comment on a couple, and then Adil will talk about a couple as well. So I guess the first point to note is that we know from previous discussion, and probably from your own knowledge, that the government of course claims that there are sort of good reasons to implement this legislation. And I suppose the first point to note is that it's not really about the intention when you're assessing discrimination, that whether or not the government has some kind of benevolent or positive intention or even policy aim isn't necessarily enough to rebut the idea that this is discrimination. So if it's in effect discrimination, that will be sufficient, just as a starting point. But then we look at, well, what is the justification? And again, you would all understand from previous discussion that essentially, I mean, I've summarised it, or we've summarised it here as being the legitimate aim is purported to be, at least in terms of sort of refugees, that one, to recognise the special needs of certain persecuted persons or refugees who've sought protection in India, and two, to respond to their predicament by facilitating their naturalisation, presumably so that they can fully integrate into Indian society. Now, of course, the word refugee isn't actually used in the statement of objects, but the word persecution is used consistently, and as we know, that certainly invokes the concept of refugeehood. I guess what our sort of core response to that argument is that we think the difficulty with stating this as the objective is that the law, as you would know, the CAA itself, it doesn't define those who are eligible for naturalisation by reference to their refugee status. It's actually silent on concepts of persecution or refugeehood. So all of this is in the sort of explanatory background material, but not in the Act itself. And although, as we know, India hosts a large number of refugees and is a member of the UNHCR Executive Committee, and of course permits the presence of UNHCR, we know that it's not a party to the convention. It doesn't have a domestic procedure in place, and we've heard previous presentations about that. And so our argument is that there's no definition in the CAA itself around these matters, and nor is there any pre-existing legal basis on which matters such as persecution in their daily life, which is one of the phrases from the statement, or persecution on grounds of religion can be assessed. And so our argument is if these matters are not part of the test, then there's surely doubt cast on the argument that the law can fairly be described as having the objective of protecting persecuted populations. In other words, how can the law be said to be about refugee protection if refugeehood is wholly irrelevant to the qualification of the law's benefits? One of the, I guess, just on that point of naturalisation, interestingly, if India were a party to the Refugee Convention, it could potentially rely on Article 34, which requires states to facilitate naturalisation. So the argument might be that India is actually fulfilling that obligation by essentially making it easier for a certain group to be naturalised. The difficulty with that, though, is that Article 3 of the Refugee Convention, which is a provision that no reservations can be made in relation to, which you might say indicates the importance of that provision, actually says that every single provision in the convention must be delivered without discrimination as to race, religion, or country of origin. So that seems to speak precisely to the context here. Look, I think I might just leave it there because I've realised I thought I would only speak for about 3 minutes, but I've just got a bit carried away. So I might hand over to Adil. But as I say, we're really just trying to pull apart each of the arguments in the statement to assess it. And there's a few other points we make there, particularly around the what might be considered the arbitrary deadline of 2014, and we think about whether that means or could found an argument that in fact this constitutes an arbitrary deprivation of nationality as well, where deprivation is understood to relate to both denial and active withdrawal. But I might hand over to Adil now to address some of the other points.
Many thanks, Michelle. And I'll try and be quick, so maybe you can come back at the end as well. And thanks to Christos and Maria as well for agreeing to commentate, and Christos for chairing. So I wanted to briefly go over the sort of two remaining subsections in the brief, namely subsection 6C, which pertains to sort of scrutinizing the return to country of origin as a legitimate ground for the distinction made under the CAA regarding country of origin, and 6D, which pertains to scrutinizing minority protection as a legitimate ground for distinction made under the CAA based on religion. So here I don't want to summarize these sections, but I wanted to hopefully clarify them by highlighting some aspects contained therein that might be a bit subdued in the original drafting, or sort of maybe badly formulated, and to articulate the background reasoning behind some of the choices we have made in drafting these subsections. So I would also highlight that what is otherwise passing as merely assumed or unstated in the CAA and its statement of objects and reasons um, has been the key guiding method for drafting these subsections. We feel that naming and unpacking these two related and almost subterranean justifications. So it's if you really have to unpack the statement of objects and reason, even that, where there are a lot of clarity to bring these justifications out. So they are sort of they effect as assumed sort of justifications is something that needs to be sort of worked through, and that's our idea behind. And we feel it's strategically significant as well. So, firstly, in order to name and clarify what is implicit, what is an implicit justification for the CA in terms of the right to return, we have taken seriously the association sought to be made by the drafters of the CAA in terms of making a connection and association with the partition of India. And in doing that, some of the particular legal, sort of international legal concepts associated with this sort of constitutive event and practice. So taking seriously the contest between, let's say, the liberal center and the Hindu right over the enactment of the partition in the 40s, and some of the ideas that were sort of being contested and played out at that time, has been helpful in sort of thinking of this area and this sort of argument of repatriation and return. So to sort of briefly sort of put it, if the Hindu rights understanding of the partition as a population transfer and a population exchange entailed an understanding of the movement of populations as a repatriation. So the sort of the Hindus and Sikhs are returning home. While the sort of liberal center and what was the sort of the government at the time's understanding of the partition as a voluntary population exchange, and of course ethnic violence that ensues at that, had an understanding of the movement in terms of refugee flows. And in fact, that is one of the grounds for India not signing on to the Refugee Convention, because of the non-recognition by the international community of these populations as refugees. So I think that's been something that we've been thinking on. That's been helpful in sort of bringing up this sort of unstated understanding, which by draftspeople who have explicitly referred to this as a relitigating the partition or revisiting the partition. The second point that I wanted we wanted to bring out was in terms of clarifying some the argument made in the minority protection subsection, namely that the association made between minority protection law and the principle of peace and security, maintenance of peace and security, or minority protection is conflict resolution. The point made therein is based on the understanding, so that it's the unilateral nature of this refugee sort of minority protection under the CAA, or sought to be exercised, as well as its association of ethnic sort of kinship between, or sort of region rigid religious kinship between the state of India and the communities in Pakistan, Bangladesh, and Afghanistan. That is the problem. There again, you have an insight into older concepts being revisited and brought out. In a way, what is sought to be the articulation of persecution in the Statement of Objects is an Article 27 sort of articulation of what are minority rights. But the means of protecting minority rights that is articulated and practice is a pre sort of UN, pre League of Nations conception of minority rights being protected internationally by a kin state in which is protecting its skins in other states. So that's the, in a way, the background, and that's why the reference is also to Nazi practices in the footnotes. So finally, I just wanted to sort of second what Michelle was saying in terms of some of the feedback we are looking for in terms of strategy and form. Mainly, as again, to say it's audience, who are we writing this for? So the assumed audience in a way is, yes, lawyers who are going to appear before the Supreme Court, but if any suggestions in that on that front, including in terms of how we might sort of draft it with that in mind, any suggestions on that front? The other thing being, of course, authorship. So in the sense, how do we get, is it a good idea to get, other people to sign on to it? How does one sort of have this as a sort of a legal brief issued by international experts or jurists at large with an expertise in this area? And finally, the form of publication. So, is this something that one would want to put out as an in a journal, in as a legal brief, or what have you? So, that's some of the things we were hoping to also get feedback on. Thank you.